Hello, my name is Richard Goldstein. I'm a partner in the pensions group at Mayer Brown. Welcome to the first episode of our new monthly video series. In these videos, we will cover different topics each month, providing an overview of issues faced by pensions industry practitioners and offering some practical insight. The time spent watching these videos can count towards solicitors and PMI CPD requirements. Please contact us if you require further information, and details will be provided at the end. All videos are available on our Mayer Brown YouTube channel, and you can subscribe to this channel so that new episodes are shown automatically to your subscriptions feed. In this episode, I'm going to be talking about the issue of DB SUPERFUNDS, and in particular the government's recent consultation on authorisation and supervision framework for DB SUPERFUNDS. A DB SUPERFUND is a commercial consolidation vehicle into which employers can transfer their DB pension liabilities. It's essentially a master trust scheme supported by a capital reserve. The employer's obligation to fund the liabilities ceases upon transfer to the SUPERFUND. SUPERFUNDs can be set up under the current legislative framework for DB schemes, and there are currently two main SUPERFUNDs, Clara Pensions and the Pensions SUPERFUND. A SUPERFUND broadly comprises a corporate entity which acts as a statutory employer, an occupational pension scheme administered by a trustee board, and a capital buffer provided by investors. In December 2018, the government published a consultation on an authorisation and supervision framework for DB SUPERFUNDs. The consultation sets out proposals for a statutory definition of a SUPERFUND, a framework for the authorisation and supervision of SUPERFUNDs, and rules on which schemes can enter into a SUPERFUND. Schemes falling within the statutory definition of a SUPERFUND would be required to obtain authorisation in order to operate. The pensions regulator would be responsible for the authorisation and supervision of SUPERFUNDs. The consultation proposed that consolidation vehicles with the following features will fall within the definition. 1. An occupational pension scheme set up for the purposes of consolidating DB pension scheme liability. 2. The transferring scheme's link to a seeding employer is severed upon transfer to the SUPERFUND. 3. The SUPERFUND's covenant is a capital buffer provided through external investment. And 4. There is a mechanism to enable returns to be payable to persons other than members and service providers. As an occupational pension scheme, a SUPERFUND would be subject to the usual legislation and regulation applicable to occupational pension schemes. Under the proposed authorisation criteria, a SUPERFUND would need to demonstrate that it can be effectively supervised, is run by fit and proper persons, has effective administration, governance and investment arrangements, is financially sustainable, and has contingency plans in place to protect members. The consultation proposes that financial sustainability or adequacy should be assessed by either a pensions-based funding requirement approach with an added test of probability of success, or an insurance-based approach using a Solvency II type balance sheet. Schemes would need to demonstrate a 99% probability of paying benefits in full and a less than 1% probability of scheme failure. The consultation proposed that there would be a hierarchy of funding levels or triggering events with associated consequences. The minimum funding level, where the SUPERFUND's assets and buffer fall to below the PPF funding level. Should this occur, any remaining capital buffer would have to be paid into the SUPERFUND, and the SUPERFUND would have to be wound up. The Tier 1 level, where the SUPERFUND's assets and capital buffer fall to less than 90% of the authorisation basis. Should this occur, any remaining capital buffer would have to be paid into the SUPERFUND, and the SUPERFUND would have to be transferred to another SUPERFUND or wound up. The Tier 2 level, whose terms need to be determined but would be higher than Tier 1, should this occur, the SUPERFUND would not be able to accept any more transfers in. The Tier 3 level, again, the terms are to be determined but would be higher than Tier 2. Should the SUPERFUND's funding fall below this level, there would be a prohibition on profits being taken from the SUPERFUND. The capital buffer would be owned and controlled by the superfund corporate entity on behalf of the investors. The scheme's assets would be owned and controlled by the superfund trustees. The consultation sets out two options for how the capital buffer could be called upon by the trustees. The first, assets would be transferred from the buffer into the scheme to make good deficits as they emerged, or the second, assets in the buffer would be ring-fenced if the deficit becomes too large, but would cease to be ring-fenced if the funding level improved. The pensions regulator will issue a code of practice on superfunds. The supervision regime will include reporting obligations for the superfund trustees and corporate entity. The trustees will be required to submit annual valuations and quarterly funding updates, and to notify the regulator of the occurrence of any triggering events. The corporate entity would be required to submit its business plan, its accounts, and a risk assessment. Both the trustees and the corporate entity would be required to notify the regulator of the occurrence of specified significant events. The consultation proposes that there would be a regulatory gateway whereby a scheme could only transfer its liabilities to a superfund if there was evidence that the transfer would enhance the likelihood of members receiving their benefits in full. Schemes at or near buyout funding would not be able to transfer. Trustees would be required to consider the scheme's current funding position on the buyout basis, any deficit reduction contributions, professional covenant advice with a clear conclusion, actuarial advice on the scheme's future funding, and the superfund's funding position and long-term objective. A potentially significant injection of capital funds would be required from the employer to meet the minimum required funding level for a transfer to occur. The consultation suggests that the minimum required funding level could be 87.5% on the authorisation basis and or 80% on the buyout basis. The consultation closed in February this year, and to date the government has not responded to the consultation. Well, that ends this video. Please feel free to email me with any comments or questions you have. My email address is rgoldstein@mayorbrown.com. That's rgoldstein@mayorbrown.com. This video is an overview of the law in this area, and how the law will apply in particular cases will of course depend on your individual circumstances. Please therefore remember to seek legal advice on your particular circumstances.